Thank you, everybody, for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we are going to spend some time discussing the E-2 visa investor requirements and considerations for the renewal of an E-2 visa. So just a few things before we get started. Some of you may know that the firm was actually founded on an E-2 visa 10 years ago. The founder of the firm, Ian Scott, applied for an E-2 visa to come to the United States to establish Scott Legal. And the firm has successfully renewed its E-2 visa as well. So this gives us very deep familiarity and expertise with E-2 visas, and we have processed hundreds and hundreds of E-2 visas for now. Now, Scott Legal is a full-service immigration law firm, but we do focus primarily on E-2 visas. We have processed hundreds of them, and we process many E-2 visas that are higher risk. And that typically means with a lower investment amount. We have processed at consulates around the world, but our primary two consulates are Toronto and London. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different topics regarding immigration law. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send out a copy of the PowerPoint that will be used in this webinar today. We will also send you all a comprehensive guide to the E-2 visa that you can use as a resource. We will also send you a link that you can follow to where you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we encourage you to subscribe to our channel and hit the notification button as we do regularly upload a variety of immigration law related videos. Finally, we will also send you a link that you can follow that you can set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. As for today's panelists, we are lucky to have Dustin Saldarriaga, who is a senior associate of the firm, who has a leading expertise on all sorts of processing a wide variety of E-2 visa cases around the world. Finally, for any question you may have, please feel free to add them to the chat box or use the Q&A function, and we will get to all questions. So without further delay, I will start the presentation. Now let's begin by talking a little bit about the overview of the E-2 visa and the rules and regulations. So in a general manner, the treaty investor E-2 visa is a non-immigrant visa. And it is a visa that allows nationals of certain countries to come to the United States to develop and direct the operations of an enterprise in which he or she has invested. Now, the E-2 visa won't necessarily lead to a green card directly, but the applicant can continue extending the E-2 visa indefinitely as long as the applicant continues to meet the E-2 requirements. Now, it is worth noting that there are 2 options that an applicant can follow when they wish to obtain an E-2 visa. The first option is they can purchase an existing business in the United States. So this is, a business purchase. You will, get the ownership of an existing enterprise in the United States. The second option is that you can establish your own startup enterprise in the United States. And for that, you will invest in the cost that is related to starting up that business and getting it to the point where it is ready to go, ready to become operational as soon as you receive the E-2 visa. Now, in order to qualify for the E-2 visa, there must be a treaty between the U.S. and the country of your nationality. And many countries, a variety of countries around the globe have this economic treaty that allows for the E-2 visa. This includes many countries from Europe, Africa, Asia, Latin America, and the Middle East. And for some examples, common examples include, nationals of the United Kingdom, nationals of Mexico, nationals of Canada, Chile, the Philippines, Singapore, South Korea, for example. They all participate in this program. This list is updated from time to time. So, for example, Israel was added relatively recently for the E-2 program. Some countries that are notable that do not participate in the E-2 program includes China, India, and Russia. There are 3 major countries that do not participate. The last topic to cover is how long is your E-2 visa valid for? So This varies greatly by your country of nationality, and this is really dependent on what is called the reciprocity schedule, and you can look it up online by searching reciprocity schedule, Department of State, and this can vary from as short as 3 months to up to 5 years. And it is important to note that the validity of the E-2 visa itself is different from the length of time that you are authorized to stay in the E-2 status once you obtain admission to the United States. So for example, let's say your E-2 visa is valid for 3 months, right? If you're from one of those countries that have this short validity period. Now, the 3-month validity of the E-2 visa gives you that 3-month window to travel to the United States on an E-2 visa and gain admission as an E-2 investor. Now, once you do gain the admission as an E-2 investor, you can stay for up to 2 years, and this is really dependent on the validity period of the I-94 that you are given at entry. So the validity period of your visa is something different than the validity period of your period of authorized stay, and you will get that period to work on your business once you are there. All right, so let's dig a little deeper into what are the E-2 visa requirements, what are the requirements that you must satisfy to be approved for the E-2 visa. So the first requirement is that you must be a national of a treaty country. And as I mentioned before, treaty countries are the list of countries that have signed that economic treaty with the United States such that they are, they participate in the E-2 visa program. Now, being a national of a country means that basically you have a passport of that country. It does not depend on your country of birth. So for example, let's say you're a dual national of one country that is a treaty country and one country that is not a treaty country. Then it is possible for you to obtain the E-2 visa through the treaty country nationality that you have if you're a dual citizen of those two countries. The second requirement is that you must make an investment. Now, what does an investment mean, right? So it is important to note that investment means that funds are put at risk. And this means money was actually spent, and if you're starting up a business, actually spent on, tangible expenses like signing up for a commercial lease, purchasing computer equipment, hiring an employee. You actually spend money to get those things in place to set up the business. And it is different from just transferring money over to a business bank account. So it is a very important distinction, right? Because if you just transfer funds and they are sitting in the business bank account, the government may think it is not put at risk because it is possible that you will simply pull back the money and there will be no restrictions of you, pulling it back into your personal account. So it is possible that they will not consider that money as money placed at risk. For example, if you are, let's look at the situation where you're purchasing a business, right? So if you transfer the entire purchase funds to the seller of the business, then yes, definitely that will be considered funds placed at risk. Now, there's another option you can use where if there is a third-party escrow account that you may use, such that you want to have the escrow be released on the condition that you're approved for the E-2 visa, because maybe you would like that extra security of what happens if your E-2 visa is denied, right? So as long as the sole condition of the release of the funds from the escrow is approval of the E-2 visa, it is possible to actually use an escrow arrangement. And in that case, you can, if you transfer the entire purchase price to, the escrow account, then that could also qualify as funds placed at risk. So that is that exception you can use in the case that you're purchasing a business. Now, another thing to note regarding the investment is that it is important to clarify what the source of the funds it is that you use to make that investment. And any legitimate source can work for the source of funds. So for example, the source of funds can be your personal savings from employment, in which case you would provide proof of, you earning that money, for example, through your income tax returns that show that sufficient amount of funds have been earned by you through employment. It can also be a gift either from someone you know. And in that case, we would go one step further and show where the person who gave you the gift earned the money from. So for example, if the gifter earned the money from, personal savings from employment, then you would also provide proof of that gifter's annual tax returns, for example, that will show where the gifter earned their funds from. Let's say sale of a property. So if the source of your funds was the sale of a house that you own, for example, you can, show that that was the source of the funds by providing the purchase sale agreement, and also bank statements and wire transfer receipts, for example, showing the money coming in from the sale, and also showing that you yourself were the owner of that particular house, and things like that. So the purpose really of this exercise is to show the government that you did earn those funds that you invested from a legitimate source. The other requirement is that the investment must be substantial. And we will talk a little bit in more detail on what substantial means. There is no hard and fast dollar minimum according to the law. However, the money that is invested must be sufficient to really get the business up and running. And typical E-2 expenditures that we see when we're logging the investments include things like you spend on inventory, you can spend on equipment, spending on setting up the website, purchasing a variety of office supplies that you will need, rent for a commercial lease for your office. That is also a very common expense. You can also spend on marketing, setting up the infrastructure to, really bring in the clients such that you can, start running the business once you have the E-2 visa. And also any costs that you incur related to setting up the U.S. business entity, setting up the LLC, setting up a corporation, for example, and any legal fees that are related to that, you can count as part of your E-2 expenditure. And I did mention this a little bit before, but there's a difference when you're starting up a business, you do want to make these tangible purchases. When you're purchasing a business, as I mentioned before, there is the option to use an escrow arrangement, such that you can arrange for the purchase price to be placed in escrow, conditioned on the approval of your E-2 visa. So once your E-2 visa is approved, the escrow agent will release the funds to the seller. But one important thing to note is that there must be no other conditions for the release of the funds except for the E-2 visa approval contingency. In that case, the consulate will consider that you have placed those funds at risk as required. Now, the other requirement is that the business cannot be marginal, and marginality refers to the profit generation potential, the revenue generation potential of the business. And the scale of the revenues that the business will generate must be more than enough to just support the livelihood of yourself and your family. It must be enough to be able to, for the business to be able to hire additional U.S. employees. And that is very important for the renewal considerations as well. One of the important things that you want to show at your renewal application for the E-2 visa is, the corporate tax returns that show the revenue generation history of the business ever since you were approved for the E-2 visa, and also W-2 records and other forms of evidence that show that you do have U.S. employees under your business. The other requirement is that the business must be real and operating. And this means that it is not just a paper company. The company is either already taking revenue or it is very close to being ready to start operations as soon as the E-2 visa is granted. So everything that is necessary for the business to run must be in place at the time you apply. For example, you must have already signed the commercial lease for the office. You must have already established the U.S. business entity, be it an LLC or a corporation. You must already have created the company website, because in this day and age, who does not have a company website if you're actually running a business? And it is also a very positive, element if you already have contracts with customers in the United States. And importantly, if there is any licenses that you need for that type of business that you are running, you must have already acquired that license. Now, some other requirements include that you are coming into the US solely to develop and direct the E2 enterprise. And this means a variety of things. This also means that the E2 enterprise is the only entity that you must work for. So you're not really allowed to work for any other employer that is separate from the E2 entity. If you were to, if you wanted to set up a different business, you must either have a separate E2 approved for that business, or any business to business relationships must be under your E2 entities. So technically, you must always be, working for your E2 enterprise, because that is, the scope of your work authorization. Another important requirement to think about is that you must have majority ownership of the E2 entity. So this means you must own at least 50%. So 50% or above, that is considered a controlling interest. Finally, the final requirement is that you must have the intent to return to your home country after the expiration of the E2 visa. As I mentioned before, the E2 visa is a non-immigrant visa, and you must, submit a declaration, a signed statement by you that confirms that your intent is to run your business, and once your, business, enterprise is finished, you will return to your home country. All right, so let's talk a little bit about the investment amount. So how much investment is enough to, meet the substantiality requirement? So it is worth noting that there is no minimum hard and fast dollar amount set in the regulations or the law on how much investment is enough to be considered substantial. And what is substantial really depends on type of business that you're starting. Also, it depends on where you apply. So certain consulates around the world have a higher standard on what they will count as a substantial investment. And also the individual examiner who looks at your case may have different expectations on what amount will count as substantial. And also depends on the overall strength of your case. So for example, is your case very strong on marginality and real and operating requirements? So for example, do you already have client contracts in place that really show clearly that the business is ready to start operations and has that revenue earning potential? Do you already have employees, for example, in the United States that can, support your marginality requirement? In those kinds of cases, and for example, is your business already earning revenues? Those kinds of facts can serve as strengthening factors, such that there could be a lesser, emphasis on the objective dollar amount that you spent for the substantiality requirement. Maybe you can show that your business is ready to go in different ways. So really, this depends on the facts. Now, it is worth noting that the government uses what is called a proportionality test for a startup. When they are asking the question, how much money is required to meet the substantiality requirement? And so what the proportionality test means is that the smaller the total costs needed to set up a business, the higher proportion of these costs must already have been spent. So for example, if you're setting up a small consulting company that will only require about $80,000 to set up, right? The government will expect that you have already spent 100% of all of the $80,000 that is required to set up that particular type of business. By contrast, if you are investing in a 100 million business, right? Even if you spent 10 million, towards setting up that kind of business, such that 10% of what is required has been spent, that is also likely to meet the substantiality requirement, even though the proportion that you spent is much lower, just because the total cost that is associated with starting the business is so high. But yeah, suffice it to say that if you are setting up a smaller type of business, the government will typically expect that you will have already spent 100% of what is required to set up that kind of business and getting it up and running. So CPA letter, business articles, those are some third-party evidence that you could use to, support the claim that you have spent 100% of what is required to really get that type of business up and running. Now, what if you are buying a business? The exercise that you want to do is compare the cost of buying that business to the fair market value of that business. So, for example, if you bought the business in the open market, chances are that you likely paid the fair market value, and that will be considered a substantial investment. Now, what if it was not an open market transaction? What if you bought it from an acquaintance that you know? So it was a closed market transaction. In that case, what could be a good idea is to get a CPA letter confirming that the price that you paid is actually equivalent to the fair market value of the business in the open market. If you get that, then there is a better chance that you will be able to support the substantiality argument. Another point that we would like to make here is that franchises can be a good option for E2 visas. That is a common question that we get. Franchises are good because any cost that you pay to the, for example, the franchise fee and things like that, you can also include in your investment in starting up the business. And also franchises typically, have marketing support and, training support for business owners and can provide that, assurance that your business will, have that support when you're, setting it up and operating it for the first time. And common good and bad E2 visa expenditures. There are some expenditures that are more favorable in meeting the substantiality requirement and, being considered as part of the investment as opposed to other expenditures. And to say some examples, the legitimate types of expenditures that are usually, expected for setting up a business, such as setting up a commercial lease, buying computer equipment, hiring an employee, legal fees, and setting up the business and, related advice, payments to contractors, for example. All of those expenditures are considered good expenditures. Some less favorable expenditures to count in your investment include things like transportation costs. If you attend a conference, you typically don't want to include the cost of the flights to those conferences. Meals, entertainment, even if they're for business development purposes, you would not likely include them, in your E2 investment. And for example, a vehicle, you do want to be careful with company vehicles. So if you're a founder of a consulting-based business, and if you just use the vehicle just to go to and from your work and your home, that's likely not a good expense to include in your investment. However, if you are a construction company, for example, and you do have that legitimate need for a truck to, transport equipment and workers, for example, maybe then it is a good idea to include that expense. So it definitely is a fact-specific inquiry, but generally vehicles can be a risky expense to include. All right, so let's move on to the next topic, also a common question that we get: do I need to hire employees? So do I have to hire employees? And the short answer is yes. Because of the marginality requirement, the government will expect that the U.S. enterprise will, bring in enough revenues not only to just support the investor and his or her family, but will support the hiring of U.S. workers. And your role will really be focused on directing the business as opposed to doing the on-the-ground work. Really, the government will expect that your employees will be doing the on-the-ground work. So the answer is yes. And how many employees should you, project hiring if you are, initially applying for an E2 visa? And if you're applying for a renewal of the E2 visa, how many employees would it be ideal for you to have while you apply? We would recommend having at least 3 to 4 full-time W2 employees by the time you apply for the renewal, or if you are applying for an initial E2 visa, in your business plan, leave room to project that you will hire at least 3 to 4 employees by year 5 of operations. And let's compare W2 employees versus 1099 workers. So generally, W-2 employees, full-time employees are favored when we are talking about hiring employees for E-2 purposes for meeting the marginality requirement. Now, in some cases, hiring contractors, 1099 workers, could be appropriate. And this will also depend on your industry. So in certain industries, it is the industry practice to hire 1099 workers rather than W-2 employees, such as the construction industry, for example. Maybe it is common for you to hire multiple 1099 workers to do the work instead of hiring W-2 employees. In that case, you will show that you have generated sufficient, sufficient employment through, your forms 1099 and other forms of evidence other than W-2 employees. And so some of the common evidences that you should collect for your renewal application would include things like the forms W-2 for the employees, pay stubs and payroll reports that shows how many employees you have. Also, tax returns are very important. It shows the revenue generation history of your company. Now, if you are applying for initial E-2 visa with a new business, the business plan is very, very important. And in the business plan, you will include a projected financial chart, a profit and loss chart for the next 5 years that will show that the business has enough potential to generate enough revenue to not only support you and your family, but also to support U.S. workers. And also, you want to submit, projected balance sheet and things like that to show that your business is a viable enterprise. All right, so let's then talk about what kinds of content would you ideally include in this business plan if you are applying for a initial E-2 visa at a consulate. The question then, do I need a business plan? So let's say you are starting up a new business and it is a completely new startup. You are, starting your own enterprise. In this case, definitely, yes. The answer is yes. You will need a business plan to really convince the, examining officer that your business will meet the marginality requirement and hire U.S. workers. Like, what is the profit generation potential of your business, and what are the assumptions that you are using to project those revenues in the future? So a business plan, a very detailed business plan would be very helpful. Now, let's say you're purchasing an existing business. And let's say the existing business has been doing well, over the past 3 years, for example. And let's say you can prove that the existing business has been doing well with tax returns, the existing business is W-2s and, objective evidence like that. In that case, maybe you may not need a business plan if the existing business is already doing so well. However, let's say you're purchasing an existing business, but that existing business has not been performing so well over the past 3 years. In that case, maybe having a business plan is a good idea to show what you will change in running the business such that you will have those additional hires, you will, boost those revenues for the future years to really show that the business will, comfortably meet the marginality requirement. In those cases, having a business plan may be a good idea. Now, let's then talk about some of the common content that the business plan should contain. So the business plan should first contain an executive summary at the front. And this really gives a snapshot of what the business does, who you are, and what are the major offerings of the business, and what is the target customer pool of the business. So who you are, what you do, who do you sell to. Now, ideally, the business plan will also contain some market analysis and research, really showing that there is demand for that type of services or products that you're offering in that particular area that you were planning to set up your business. A marketing plan is also a very important aspect of a business plan because it will show how the business is planning to gain leads for clients in the future. And this can include, your plans for setting up online marketing channels. This can also include plans for paid advertising. This can include plans, for public relations campaigns and mailers and things like that. But the government will definitely want to see what are your plans to continue gaining those leads. A personnel plan is also very important, and also relating to the marginality requirement that we've been talking about. The business plan will ideally have 5 years of hiring projections, and those hiring projections should be detailed, including the job description of the people that you are planning to hire, the projected salary that you are planning to give to those employees, and also talk about the timing when you will hire each employee as the business grows. So for example, in your plans, you can maybe project that you'll hire 1 employee by the end of year 1. You can, project that you'll hire, 2 to 3 more employees as the business grows in line with the business progress. Also, what is an important part of a business plan is including a comprehensive financial plan. And for example, a profit and loss statement that you project out the next 5 years that will show how much are the expected revenues coming in for each year, and what are your assumptions behind those revenue calculations. And this can be a function of things like how you will be pricing your services, multiplied by the expected volume of cases that you will have, for example. Another thing that could be helpful is a chart that shows your cash flow. Will you be cash flow positive? How will you be getting the cash to operate your business? Also, it is helpful to provide a projected balance sheet for the next 5 years to show that really the business is viable. Now, the question also arises, do I need to hire a professional to write the business plan? And it really depends on, how comfortable you are with preparing all this content. One thing to note is that even if you do hire a professional to write your business plan, you do need to be very familiar with all of the revenue projections, all of the hiring projections, all of the numbers basically that you write in the business plan. Even if a professional writes it for you, you need to be able to understand everything and to really advocate for yourself in the E-2 visa interview, and be very familiar with all of the assumptions that went behind calculating those projections. And definitely a professional could help you, sort of arrive at these numbers. They can give you some feedback about, the assumptions that you use and the reasonability of the projections. So it can be very a good idea to have a professional helping you in really shaping those plans. However, at the end of the day, at the E-2 visa interview, you will be expected to be able to explain everything that is contained in the business plan.
Great. Thank you, Jiyae. So we will be moving on to talk about E-2 visa developments and adjudication trends. Jiyae covered a lot of great information, so there are some things that I'll kind of skim over since she did a great job of sharing that information with you all. But let's go ahead and get started by talking about one change that we've seen, which is that consulates are becoming, it seems, more sensitive about where the investment funds have been spent. And specifically, what we see is that consulates want to see that the investment amount that Jiyae mentioned before, where you need to invest a substantial amount that's enough to make the business operational, that those funds, a majority of those funds, should be spent in the United States. So an example of where you might get in trouble with this is, let's say that your business is buying inventory from China and selling it in the US, and you've invested $100,000 into the business. You've spent $80,000 on inventory in China. And the rest of the funds you've spent in the US on computers, on a business space, things like that. It could very well be a problem that you've spent so much on goods outside the US. So our general recommendation is that you make sure that a majority of your funds have been spent in the US. So if you have the option of buying inventory in China or in the US, and that inventory is a significant part of your investment, try to spend it in the US. Same with marketing. We have clients who sometimes use marketing companies outside the US. If your marketing budget is significant, it's a big part of your investment amount, it could be worth looking for a marketing company within the US rather than using one abroad. Unfortunately, the second bullet, administrative processing, is one of the more concerning and frustrating developments. since the COVID pandemic, we've noticed that consulates have tended to more frequently put applications in administrative processing. And what administrative processing is when you've submitted an application, you oftentimes have gone to your interview, and then the consulate tells you, great interview. Looks like this application can be approved, but we have to do a more significant security check on it. And oftentimes they will send the application from the consulate to the United States for any number of government agencies in the US to look into it. It could be the FBI, it could be the CIA, Department of Homeland Security. But point being, you typically will not get any transparency on what's being done during the administrative processing period. They won't tell you why your application's in administrative processing. It is really a black box, and it could take months. Fortunately, this is not common. It's still not common, even though it's more common than it used to be. But it is important to know that it's a possibility. It could happen. We filed dozens of these applications, and in a handful of those cases it's happened. In the vast majority it does not happen, again, fortunately. But something to be aware of, that it has become more common than it was before. And there's really nothing you can do to counter administrative processing short of suing the government. You can sue if a significant amount of time has passed. So for example, if you've waited a year or more for the application to come out of administrative processing, you may be able to file a lawsuit in federal court. We do handle those cases, and the government is oftentimes responsive to those, and it could bring the application out of administrative processing, though there's really no guarantee of that. More USCIS filings. This is a trend that really was boosted during the COVID pandemic. So there are two pathways to apply for E-2 status. One is at a consulate, which is the most common pathway. Jiyae talked about the difference between a visa and E-2 status. You can only get a visa, an E-2 visa, at a consulate outside the US. From within the US, you can apply for E-2 status. So if you're in the US as a student, you can apply to change your status, for example, to E-2, but you cannot get an E-2 visa from within the US. And what that means is, if you don't have a visa, the moment you leave the US, if you've applied for a change of status to E-2, you lose that E-2 status, and you have to get the visa from abroad if you're going to come back in E-2 status. Now, for obvious reasons, because having status doesn't allow you to travel. Also, USCIS applications tend to be more difficult in terms of proving where your funds came from, that you've invested in the business. And it's also more expensive. USCIS is more expensive. There are a range of reasons why consulates are preferred in general to USCIS, though there are exceptions. So it doesn't make a lot of sense for many people to apply through USCIS. Typically, a consulate does make sense, but during COVID, when it became very difficult to travel to a consulate abroad, USCIS filings became much more common. And we've seen that more people are willing to go that route now. The other situation where I'd say it's helpful to do a USCIS filing is that if you're in the US and you really want to start working for the E-2 business soon, then USCIS offers the option of premium processing, which will get you a decision within 15 business days. It is a significant fee of over $2,500 to get that expedited decision, but consulates don't offer that. So typically at a consulate, you're going to be waiting at least a month. Depending on where you're applying, it could be up to 6 months or even longer than 6 months, depending on the consulate. So if you're in the US and you want a quick decision, USCIS really can be a great option. Also, if you have a low investment amount and you're within the US, USCIS tends to be less sensitive to low investment amounts. So I've already touched on some of the COVID-19 issues. For example, it's more likely for someone to consider applying through USCIS as a result of what we saw during the COVID pandemic. But unfortunately, one of the lasting consequences of the pandemic is that consulates have been very delayed. During the pandemic, we were seeing consulates um, experiencing delays of a year or more, where you'd submit the application and be waiting a year for your interview, which was extremely long. Fortunately, now it really is one or two consulates in the world that are seeing delays like that. Those are very long, very unusual delays. Now we are seeing delays closer to about 3 months. Toronto, which is the consulate we interact with most frequently, we are seeing them turn around applications between 1 to 3 months from the date we submit the application. So fortunately, many of the COVID-19 issues are much less of an issue now that some time has passed. Let's talk about some issues and complex areas for E-2 visas. Um, Source and trail of funds. I mentioned before that one of the big hurdles, if you're in the US and applying through USCIS, is proving where your funds came from. USCIS will really do an accounting of exactly where every single dollar came from that you're putting into the business. And you do have to show where you got it from, whether that's sale of an apartment, as Jiyae talked about, could be income from work, it could be a loan, it could be a gift. Loans are acceptable as long as they're not secured by the business assets. So if it's your personal loan, that is fine. A credit card, your personal credit card is fine. That's an unsecured loan. However, a business credit card is not okay because that would be secured by the business and its assets. Gifts are also fine, but the thing to know is that you do, whether you're using a loan or a gift, you do have to show where those funds came from. So if a family member is giving you a loan, you have to show where that family member got the funds. If a family member is giving you a gift, you have to show where that gift came from. And this is true of consulates as well. You do have to document where the funds came from to show that they are from a lawful and a legitimate source. The difference with USCIS is that they will make no assumptions. Consulates will oftentimes make assumptions because consulates oftentimes will have page limits. So if you have a 70-page limit, you can't include all the documents showing where, every single transfer of funds and, the entire contract for the sale of your apartment abroad. Whereas USCIS does not have a page limit. So they want to see every single page that's related to both you receiving the funds and exactly where those funds came from. Small investment amounts. Our firm is proud to kind of specialize in what we call risky and low investment E-2 cases. In fact, our firm, if we were to apply today, would be considered a risky case if we were using the same initial investment amount, because law firms do not require a large startup investment. You only need a few computers, a small space, maybe some subscriptions to some resources, and you've invested everything you need to for the business to be operational, and you might have only invested $15,000. There are ways, while that is definitely a risk, a low investment amount, it is not an insurmountable risk. And it's something that we basically every single day help our clients navigate. We have a completely separate hour and a half long webinar on exactly this topic, how to apply for an E-2 visa if you do have a low investment amount or an otherwise risky case. So do check that out if that's a topic that you're interested in. But in general, what you would want to do in those cases is look at the application holistically. And let's say you really don't have more money to invest. How can you strengthen the application otherwise? One of the best ways to do that is to hire a US worker, and to show that even though you haven't invested a lot, you've invested enough for the business to be operational and to actually employ someone. You also can get letters of interest from clients, letters from the local chamber of commerce talking about the impact that your business is likely to have on the local economy. Think creatively about ways that you can really convince the government that even though I haven't invested, 50, 60, 70 or more $1,000, I've invested enough for this business to be operational and to create job opportunities for US workers. E-2 visas for two investors. You can have an E-2 co-investor. They must have E-2 treaty country nationality, meaning a passport from an E-2 treaty country. They must also invest a substantial amount into the business, and they must own 50%. So if you have a co-owner, the only way to do that is for you each to own 50%. If there's only one E-2 owner, then as long as they own more than 50%, they're fine. But if you have two E-2 investors, since there is a 50% requirement, that is what each investor must own of the business. Substantive changes to the business after filing. This really is a gray area. So basically, when you submit your E-2 application, you describe to the government what the scope of the E-2 business is. I'm going to open a restaurant in the US. And that is the scope of what you're allowed to do on your E-2 visa. If you've opened that restaurant and now you decide, well, I want to start consulting for other businesses. I want to start on the side doing kind of some, maybe some Uber driving. I want to start doing selling some products on Amazon from the US. If that is not in the scope of what you described to the government, whether the consulate or USCIS, you cannot do it. The E-2 visa is limited in scope to the activity you describe in the E-2 application, because the visa really is for you to come to the US to develop and direct the E-2 company. So what happens if you get your E-2 visa and then the business changes? Let's say you wanted to open a restaurant, but that proved more challenging than you thought. So you started a pool cleaning business on the side. Excuse me. It is very important, if the change is substantial, to get approval before you do it. Otherwise, you risk violating your status. So if you are in that situation, talk to a lawyer. We'd be happy to speak with you to figure out what the best path forward is. However, if the change is not substantive, so for example, you've started a restaurant and you decide, you know what, we want to sell coffee. We want to open a little coffee shop on the side. That might not be a substantive change. You might be able to do that even though you told the government you're just opening a restaurant. So that's why I say it is a gray area. If you have already done this and you didn't disclose it to the government, you may need to let USCIS know. Although again, it's important to talk with a lawyer to figure out exactly what you need to do there. And finally, family business purchases. If you are purchasing a business from family, you need to be careful, because the government wants to know you actually spent what you needed to spend on the business and you didn't get any kind of preferential pricing. So your family may want to market the business on the open market and show that you actually paid that amount. Excuse me. All right, so let's look at some common reasons for E-2 denials. We've already talked about a number of these. Low investment amount's a big one. Again, think about holistically how to strengthen the application, and we have a separate webinar on that topic. So do check that out if you're interested. There are certain businesses that are just innately risky based on the type of business. So, excuse me, real estate businesses, investment businesses tend to be risky because the government oftentimes is not convinced that they are what is defined as real and operating, and that they would require the employment of US workers. So for example, if you're purchasing land, hoping that it will appreciate in value and you'll sell it, the government would not consider that to be an operating business. It's more of a passive business. So if you're doing something like real estate, you want to make sure to show that it's a business that requires workers. So say you're flipping homes, you want to show that you have people on your payroll, that you actually are flipping a significant number of homes, that it's not just one or two homes. You want to show that you actually need an office space to house the workers who will be working on flipping the homes, doing construction work, etc., advertising your business. So make sure that the nature of your business really is one that's real and operating and that will employ US workers. And again, the businesses that we see have the most issues in this regard are investment companies, and real estate companies specifically. So if you're looking at getting into those areas, do reach out and schedule a longer consultation with us. The filing location. Some consulates are just stricter than others. Some expect to see a larger investment amount. And so one of the services we help our clients with is figuring out where the ideal place to apply is. Again, we can discuss that through a consultation, which consulates are better or worse to apply at. Concern over whether the business will create jobs for US workers. This is a big one because this really is a make or break aspect of the application. If you have failed to convince the government that your business will employ US workers, you are looking at a likely denial. And it doesn't matter if you've invested $10 million in the business. If the government doesn't think you're going to employ US workers, you will probably not get the visa. Conversely, if you can convince the government you will employ US workers, then you can get away with possibly falling short on other requirements, such as the investment amount. Again, if you've invested, hypothetically, $20,000, but you already employ 3 people and you're generating revenues of $500,000 a year, you're likely to get an approval, assuming everything else looks good. So employment really is key and can make or break an application. Issues with the adjudicating officers. So you're dealing with people at the end of the day, whether it's a consular officer or a USCIS officer. People have bad days. People sometimes miss things. So sometimes you just draw an officer who doesn't want to approve the application. And unfortunately, there's not much you can do about that if you're applying at a consulate. You can apply again, which is fortunate. And oftentimes consulates will try to assign the case to a different officer if you are denied the first time. USCIS, you do have more options to appeal or challenge the decision, though usually what ends up happening is you will learn from the consulate or USCIS what the weakness in the application was, what issue they had, and then usually you can address that. Now, we see so many of these applications that we typically can flag those issues beforehand, so you don't face that initial denial. But sometimes you just are at the mercy of the officer and there's no getting around that. And filing again is the option you have. Lastly, sometimes you just don't meet the requirements. Sometimes, there's an issue with the ownership percentage, or oftentimes if there's more than one investor, you might have an issue with the role that one of the investors is playing at the business. But again, we tend to see this when clients come to us after having applied either on their own or with another firm. We are usually going to be able to flag those issues before the application goes out the door. So what does it take to renew an E-2 visa? First on your list, we'll say it again, hiring workers is key. We do recommend at least 3 full-time equivalent US workers within 5 years. If you have a startup, you would show that through a business plan. And that business plan would have clear financials explaining all of your assumptions, how many products or services you're going to sell in year 1, 2, 3, 4, 5, what that is going to create in terms of your revenue, what workers you'll need to support those sales. And the business plan will just logically lead to the number of employees the company will need. Adding to what Jiyae said before, this is why I think it is very helpful to work with a firm like ours on even the preparation of the business plan, because our intended audience is a consular officer or a USCIS officer, whereas many, if not most companies that prepare business plans, that's not the intended audience. The intended audience might be investors. It might be collaborators, other sources of funding like the government. So it is important to work, or if you're preparing the business plan yourself, or if you're working with a company, to make sure that your intended audience is a government official who's looking at, approving a visa or E-2 status. So you would also in a renewal provide updated financial data. Many consulates allow you to apply with a streamlined application if it's a renewal and if the business is going well. And usually what that would include is your most recent tax returns that are showing your sales, your profits, compensation paid to employees. would typically include W-2 forms or 1099 forms, which are the tax records that go to employees or to independent contractors. And really, once you've shown that the business is generating funds through your tax returns and that it's paying people through W-2s or 1099s, that's the bulk of a renewal application, really. We might include more if the business is struggling. So, for example, if they haven't hired anyone until, say, year 4 or year 5, maybe they only have one employee, we might recommend that they include a business plan that shows the next 5 years and how the company is going to overcome whatever challenges it's faced. But in general, if the business is doing pretty well and is employing, 3 workers, a renewal application is typically going to rely on those tax returns and compensation records to show that employees are being employed. You see here on the bullets, did the company meet its revenue targets and did the marketing and sales plan work effectively? Frankly, if you're applying to renew your visa and you have hit 3 employees, usually it doesn't really matter all that much if you hit your targets. Let's say your target was to generate, $2 million a year in revenue and you only hit $1 million a year, but you're still employing 3 people. The government might ask why you didn't hit 2 million and you hit 1 million, but at the end of the day, the application is very likely still approvable. But for this reason, I do think it's good to be conservative in your initial application. There's no need to try to impress the government with home run figures. The goal is to convince the government that you'll employ at least 3 workers and that you will generate enough revenue and income to support those workers. So once you've shown that, you don't need to go beyond that. Now, if you really do believe you're going to see figures far beyond that, it's fine for the business plan to show that. But if you're not confident in those figures, I'd recommend not putting yourself in the position where you're having to explain away not hitting the large figures you projected before, as opposed to showing the government, hey, we actually surpassed the figures that we presented in our initial application. And finally, does the company still meet the E-2 requirements? So make sure your ownership never drops below 50% if you're the E-2 investor. The moment it drops below 50%, you lose your E-2 eligibility. That is a threshold requirement. And finally, changes to the type of business. If you're looking to expand what the business is doing, if you're looking to buy a new location and you're wondering, should I start a new LLC to own that location? These are questions that, it is important to talk with a qualified lawyer just to make sure you're not going outside the scope of what you're allowed to do on your E-2 visa. The E-2 visa is tied to the E-2 company, which is usually a specific LLC or corporation. So, if you create a new LLC that you start working for, technically that is a violation of your status. So you need to be very careful in how you frame expansion and how you frame changing the business. It's not something you necessarily at the end of the day have to avoid, but you do need to be careful about how you do it. And there are ways to do it that preserve your visa, your E-2 status. So could be an important situation where you reach out to an attorney. And we're happy to discuss that through a consultation. So I think we actually addressed any questions that came in. I don't think we have any other questions. And we actually are right at about time. Oh, we do have a question. All right. So I have a question on the renewal of my E-2 status after 2 years. I'm worried I'm not able to hire more full-time employees within 2 years. Business is a tutoring center for students. Can I purchase an existing tutoring center franchise under my E-2 LLC? Is it considered as expanding my business? The tutoring center franchise already has more employees and has revenue for 6 years. So I think fundamentally the question is, can I purchase an existing tutoring center franchise under the E-2 LLC? So there are ways to do that. Again, your E-2 is tied to your LLC. So the LLC that you own and the that you own at least 50% of, and the LLC that was approved by the government, whether that's USCIS or the consulate. So you cannot say buy a separate LLC that you are actively running, that you do need approval for a separate LLC. However, if your LLC bought the assets of an existing tutoring business, that could very well work. It would be under the same LLC that you already have. It would be, and you own 50% of, it would be aligned with what the E-2 company you already have is doing. So it's not like you're, what I said before, running a restaurant and then starting some completely different side business. You're doing the same thing. So an asset purchase could very well be fine. But I would say it sounds like you're dealing with a franchise which has its own requirements for how to do this. So I would say it's worth talking with a lawyer about it, just in case there are specific details that need to be considered there. So I do hope that's helpful, though, given that this is a high-level webinar. Great. Well, Jiyae, thank you for sharing your expertise. Always a pleasure to see you and to hear your wisdom. Everyone, please keep an eye out for our future webinars. We try to do at least two. We do multiple webinars a week now. I used to say 2 a month. Now we're way past that. But anyway, if we can be helpful at all, please do schedule a consultation and follow up on that email that we'll send you. Great. Thank you all. We hope to see you again soon. Bye-bye.